Good afternoon. This is the regularly scheduled meeting of the Sunshine Ordinance Task Force. Can we call the roll?
Member Craven Green?
Here.
Member Craven Green present. Member Nee?
Here.
Member Nee present. Member Cawthon? Here. Member Cawthon present. Member Washburn? Member Washburn absent. Member Caneva?
Here.
Member Caneva present. Member Johnson?
Here.
Member Johnson present. Member Chu?
Here.
Member Chu present. Member Chan? Member Chan absent. Member Goldman?
Here.
Member Goldman present. Member Williams? Member Williams excused. Madam Chair, we have 7 members. We have a quorum.
Great. Regarding agenda changes, I'm going to recommend that we move 1 and 2 to the back because they're to the end because they're administrative, and we'll hear from the members of the public first, unless there's any issues with that. Are there any other agenda changes? Seeing none, can you call number 3, please, Chris?
Item number 3 is the determination of jurisdiction on complaint filed by Paul Weston against the Department of Human Services for allegedly failure to respond in a timely manner.
Members, I move that we find jurisdiction on this item.
I second.
Is there any public comment on this item? Seeing none, can you call the roll, please?
On jurisdiction, Member Craven Green?
Aye.
Member Craven Green, aye. Member Nee?
Aye.
Member Nee, aye. Member Cawthon?
Aye.
Member Cawthon, aye. Member Washburn? Member Washburn absent. Member Caneva?
Aye.
Member Caneva, aye. Member Johnson?
Aye.
Member Johnson, aye. Member Chan? Member Chan absent. Member Goldman?
Aye.
Member Goldman, aye. Member Williams? Member Williams excused. Member Chu?
Aye.
Member Chu, aye. Madam Chair, we have 7 ayes.
Thank you. Before we get into the hearing, is there a representative from the Department of Human Services here? Is Mr. Weston here? Can you come up to the podium, please? We have the opportunity to continue with this hearing,
Okay.
and then there will be no one here except for what's in the packet regarding what the Department of Human Services has to say. I'm okay with that. What members, do you have any concerns about continuing without the department being represented? Okay. You have 5 minutes to tell us about your case.
Okay, thank you. I hope all of you have carefully read the supporting documents that I have submitted for this case, especially the email correspondence between myself and Pamela Thibault. I have a paper copy of it if you need it. From reading our email correspondence, you can clearly observe Pamela Thibault's attempt to play a childish game of semantics in order to evade disclosing public documents. She asked for clarification on a Sunshine request that contained no ambiguity whatsoever and required no clarification. I specifically requested a particular statement of service and invoice document. Statement of service and invoice is the title on the monthly invoice that the St. Vincent de Paul Society submits to HSA, and this type of document is extremely common throughout HSA. Pamela Thibault's request for clarification could not have possibly been sincere. It is inconceivable that she did not know what document I was referring to. Nevertheless, I played along and clarified that the phrase statement of service and invoice was the title on the document that I was requesting, despite the fact that this was painfully obvious. On May 12th, Pamela Thibault informed me that the document was ready for pickup. On May 13th, I arrived to pick up the document only to find that part of the document was missing. I had previously obtained numerous statement of service and invoice documents from Pamela Thibault, and they always contained 2 pages, page A and page B stapled together. However, on this occasion, Pamela Thibault only provided me with page A. Page B, which detailed personnel expenditures, was missing. Page B is not a separate document. Page B is a significant and integral part of the statement of service and invoice document. In fact, page A makes a direct reference to page B in its total salaries field. So I called Pamela Thibault's secretary and requested that they comply with the Sunshine Ordinance. Instead of apologizing for the delay, Pamela Thibault's secretary accused me of threatening her. And Pamela Thibault sarcastically informed me that page B would not be ready by that day and hung up the phone on me. Pamela Thibault then lied in the email that she sent to me on May 14th and copied to the task force, stating, "Our security guard warned you to calm down or he would escort you out of the building." This did not happen at all. In fact, the security guard actually agreed with me that Pamela Thibault and her secretary behaved childishly. Page B was not made available to me until May 14th, 2 days after the deadline pursuant to Administrative Code 6725. However, in my initial request, I also asked for the application and/or resume of several employees of the St. Vincent de Paul Society. Pamela Tebow refused this request on the basis that she did not have access to the personnel files, and on the basis that even if she did, that these files would be confidential. She recommended that I contact St. Vincent de Paul directly. I had already done that, but St. Vincent de Paul refused the request on the basis of confidentiality. I attempted to file a complaint with the Sunshine Ordinance Task Force. However, they instructed me that I must first resolve this complaint with HSA. Since it became apparent to me that the only way that I would obtain this information was to go through HSA, I emailed Pamela Tebow on May 21st and informed her that I had not rescinded this part of my request. Diane Christensen then emailed me that day and agreed with Pamela Tebow that HSA does not have access to personnel files. This is not true. HSA may not have direct access, but they can easily request such information from St. Vincent de Paul, and that is what they would have done if public transparency were a priority to them. Furthermore, not all of the information on a public employee's application is confidential. Please read Braun versus Taft court case that I provided as supporting documentation. In it, the court clearly establishes that, quote, employment contracts are public records and may not be considered exempt, and that the definition of a public record encompasses, quote, any conceivable kind of record that is involved in the governmental process. The application of an employee of a nonprofit organization that receives public funds to operate a publicly owned facility would certainly fall within this definition. The court further established that even if a document contains some confidential information, that this would not make the entire document exempt, but merely require the confidential information be segregated from the rest of the document. On May 21st, I informed Pamela Tebow that I was particularly interested in work history and education. As established by Braun v. Taft, this is professional information and therefore not private. I still have not received this public information.
Thank you.
Do you need copies of the... No.
Yeah, I believe we have all the copies. Is there anyone from the Department of Human Services that has arrived in support of this item? Are there other parties to the complainant who wish to present facts and evidence? Seeing none, we do have some issues with our packet. Do you want to?
There was some dispute. Actually, there's some ambiguity in the packet. Some of the information that's relevant to this item is actually under the next item number. That, in fact, this one does encompass, as the complaint reads, the request for the terms of service and invoice, and as well as the resumes for the members of St. Vincent de Paul. That's all within this complaint. Some of the substantiating document, however, were erroneously put under the next complaint. So just to make the matter clear, that's all within the scope of this complaint. The next complaint deals only, as I understand it, and as I read on the face of the complaint, with notes and minutes of community meetings. So I think there was some confusion, but we have all the relevant documents in those first two items.
Okay. The matter is with the task force for discussion and questions. Please.
And I also believe that in the June 19th correspondence, the department indicated they would be appearing on this complaint. So if they do appear, we should give them the opportunity to respond. With respect to the issue of the terms of service, I'm using the wrong phrase, the statement of service and invoice, it does look like the department failed to respond to the IDR to a document that should be readily available. They provided page 1 and not the second page, so I do think there was a violation there. I don't want to get into the back and forth about who said what and who was being childish and who wasn't. That's not really what we're here to do, but it looks like there was a violation. However, I'm not sure that we need to send that violation, if approved by the Task Force and Compliance Amendments Committee, because it does seem like it was something that was unfortunate. It did happen, but it wasn't, in my view, an egregious violation of an IDR. It was provided within 4 days. I don't believe Mr. Weston should have to go back and forth and argue with him about this. I think that is a shame that he had to follow up and advocate to get the documents he needed or he requested. However, he did receive them in the end within 4 days. With respect to the resumes of the individuals employed by St. Vincent de Paul, the issue here is not, in my mind, is not whether or not that information is confidential. Had those been city employees, that information that Mr. Weston sought or seeks is not confidential and should be produced to the extent it was maintained by the city. However, it is not maintained by the city. It is maintained by a nonprofit who the city contracts with. And even if you read the 12L, the provisions under 12L, which regard nonprofits doing business with the city of at least $250,000 or more, they have certain obligations to disclose records. Even if they qualify under that provision, they would not be required to turn over resumes or information about their personnel. It's simply not something that is covered, unfortunately, under our Sunshine Ordinance. So therefore, I believe there's been a violation of the failure to comply with the IDR, and I would hope Ms. Tebow and the department doesn't engage or doesn't have a repeat of that. However, with respect to the other allegations, I think there's no violations because those documents simply aren't covered.
Any other questions or comments?
I have a question for, there's nobody here from the department. I have a question for Mr. Weston. Mr. Weston, apparently, I don't want to get into the back and forth of it either, but apparently you were told that on May 14th that they can only pass out documents that the staff, Ms. Tebow said she could only pass out documents the staff gave her, and she said she wouldn't allow her secretary to hand deliver the documents to you, and so she was going to either fax or mail them. So how did you finally get these documents?
I picked them up in person. She first told me that it was impossible for me to pick it up with security guard, and then she retracted that.
But someone did give them to you when you went in to get them.
Security guard.
Okay. And then could you amplify Braun versus Knox? It's in your next complaint, but it's not in this one. You mentioned that it has to do with...
Ms. Cawthon, it isn't. It's, I didn't interrupt, but it is in this one. It's one of the issues that accidentally...
It's actually in the one...
It's in this one before us now.
Western versus Human Services?
It is, but it only deals...
Page 57?
It does. It should be under this complaint.
Well, I understand that. I'm just trying to ask, and since it's pertinent to this, could you enunciate again what you said about the privacy protections and your opinion on that?
Well, it defines a public document as encompassing every conceivable kind of record that is involved in the governmental process. And an application of an employee that works at a nonprofit organization that receives public funding to operate a publicly owned facility, I think is indisputable that it falls within the definition of a public record.
And you said something about the IRS form...
Oh, yes.
1023?
For instance, the IRS Form 1023 has fields that this is a document that St. Vincent de Paul had to fill out and have available for public inspection. On it, it has fields for the mailing addresses of employees. So if the IRS does not consider this confidential, then why does Human Services Agency and why does this task force?
Okay, thanks, Mr. Weston.
Any other questions?
Hanley's here and Alice.
The respondent and complainant both have an opportunity to speak again. So, Mr. Weston, you have another 3 minutes if there's anything additional you'd like to provide.
Just to summarize, I guess, my complaint consists of 3 parts. The first part is that the statement of service and invoice was not given to me on time, pursuant to 6725. Second, that the conduct of Pamela Tebow and her secretary was very childish and unprofessional. A member of the public should not have to go through what I went through in order to get a public document. And I don't know if that falls within your purview to reprimand conduct, but it should, I guess. And third is my sunshine request for employment applications was refused, and I still have not received that.
Okay. The matter is with the task force for motion and deliberation. Ernie, what are your thoughts on this issue of the employment applications?
The employment applications are with a nonprofit. It's not with the city. I don't think the Braun case is applicable here. That's dealing with city employees. We're not dealing with city employees. We're dealing with a nonprofit that is in contract with the city for specific services. That is governed under specific provisions of 12L. and possibly under 67.4. That's questionable, though, because it's based on terms of the contract, which we haven't seen. I would say that under terms of 12L, there is a limited access to information. It's spelled out in 12L what they can get: performance reports, budget reports, but not personnel information. That is not covered under 12L, and as such, I don't believe that that's releasable by Human Services. Even if they have, I mean, they don't have it. It's not theirs. They can't order the contracting agency to release it.
And just to follow up on D.C. Laurenti's comments, I believe if DHS actually had that information, if they had it, whether because they requested it or whether because St. Vincent de Paul voluntarily provided it to them, it then would be a public record subject to disclosure. However, they do not have control of it. It's with the nonprofit agency, and the nonprofit agency is not separately required under the ordinance to produce it.
Is there a motion?
Violation, oh, sorry, member name? Violation of 6725A for failure to timely respond to an immediate disclosure request.
Second.
Please.
I would like to add the respondent didn't appear. I don't know if this respondent appeared at the complaint committee, but what is that, 6721? I forget. E? E, okay, I would like to add that.
I'm hesitant to provide that. The respondent initially asked for a request for a continuance. In our packet, there's a lot of
I did see
about that. And also on the 19th indicated that someone would be here to respond to this complaint, and we've taken things out of order, and we're very early in the evening, so actually I wouldn't support that.
So
they may show up.
I think it was Mr. Curto who requested the continuance, not Ms. Tebow. And I think he was the first complaint to be heard. So I mean, I would certainly. I mean, I think when there is a complaint filed against the department, I mean, I'd like to ask the department questions. So I would like to stipulate that if they don't show up in the next half hour, that I would like to add that to the order of determination, failure to appear.
Yeah. I would be also concerned about adding that because we don't just want any random person from the department to show up. We want someone who's knowledgeable, and someone who's knowledgeable, made it clear in a very, direct manner in the time frame we needed that they couldn't make it.
Well, is Ms. Tebow not knowledgeable? She was the one who was involved, not Mr. Curto.
I'm not. I don't know.
I mean, I've read the case, so that would be my feeling.
So are we going to have another motion?
I just wanted to add that, but...
Okay, but you'd have to have these guys agree.
Second, not accept.
Is there any public comment on this matter?
Ray Hartz, and I just wanted to comment on the fact that first, the city agency doesn't send anybody at all, and having an argument over whether they someone knowledgeable or not knowledgeable is not the argument. The argument is they send anybody. They indicated at the last meeting at the complaints committee that they intended to send someone, and they did not. So therefore, it's a violation. The meeting started at 4 o'clock. It was on the agenda. I assume they were sent an agenda. They knew it was here, and they didn't send anybody. So having an argument over whether or not they might come in at 5 o'clock or 6 o'clock or whatever, I think is kind of pointless for the simple fact that, to be fair to both parties, they need to be here at the time of the hearing. I would also encourage Mr. Weston, if he wants information relating to these employees, look at the contract that was actually put out by the city. If this contract requires that people of a certain experience level or certification or whatever are required by the contract, then it would be definitely part of the public record to determine that the employees who are being employed and paid under the city contract are actually meeting the qualifications required under the contract. So I would encourage him to go forward, get a copy of the contract, and to see if there is any determination in the contract stating the minimum qualifications or requirements for the organization to have and maintain the contract and to pay it. And the whole argument about the billing is kind of ridiculous, because obviously if someone's doing services for the city, they expect to be paid, and every month or whatever the terms of the contract are, they need to send a statement of services rendered, and then the city uses that to base the authorization to pay. So for them to have arguments with Mr. Weston about, oh, well, there's not this and there's not that, the bottom line is the contract probably also states exactly what they have to report and how often as to what services they have rendered, and the fact that by rendering those services, they are in need of payment, and the city should authorize the payment. So I kind of get this whole feeling that there's something going on here that the city doesn't want Mr. Weston to see, and I would encourage him to keep up the good effort.
Thank you. Is there any additional public comment?
Yes. I'm the executive director of the St. Vincent Paul Society, and I do have to comment about that because we have given Mr. Weston the documents that he seeks in terms of the contract and our budget and our audited financials, as well as the salary of the months that he requested. So there's nothing being hidden here. It's interesting back and forth, but the truth is that we have given those documents to Mr. Weston. This isn't our complaint, but I have to add that as a matter of public record.
Thank you. Is there any additional public comment? Seeing none, can we call the vote, please?
On the motion, Member Craven Green.
Aye.
Aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams excused. Member Chu.
Aye.
Member Chu, aye. Madam Chair, we have 9 ayes.
Thank you. Mr. Weston, we will now produce a document that you will get a copy of, and so will the department, with this decision. Can you read number 6? 5?
Item number 5 is the
Aye.
determination of jurisdiction of complaint filed by Paul Weston against the Department of Human Services for alleged failure to provide requested records.
Members, once again, I move that we find jurisdiction on this item.
Second.
The complaint, I do have a question about jurisdiction. The complaint itself is against, under department, the St. Vincent de Paul Society. If this is, at that point, against a nonprofit, it must fall under the 12L provision, correct? And was that, I just want to be clear for the record, that this finding of jurisdiction is pursuant to 12L, therefore, and that this body has been making a finding that the provisions of 12L have been complied with, the prerequisites. Is to the chair of the...
Yes.
Okay, thank you.
Is there any public comment on this matter? I had one question. Did Department of Human Resources show up for the complaint committee? Okay, thanks. Can you call the question, please?
On jurisdiction, Member Craven Green.
Aye.
Craven Green, aye. Member Nee.
Aye.
Nee, aye. Member Cawthon.
Aye.
Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Knebber, aye. Member Johnson.
Aye.
Johnson, aye. Member Chan.
Aye.
Chan, aye. Member Goldman.
Aye.
Goldman, aye. Member Williams. Member Williams excused. Member Chu.
Aye.
Madam Chair, we have 9 ayes.
Thank you. Mr. Weston? You have 5 more minutes.
Okay, but I don't know exactly what complaint you're talking about because I didn't realize. Is this a complaint about the notes or minutes? Okay, I didn't realize that it would be discussed here. But I'm not entirely sure about. I haven't researched the ordinance pertaining to public meetings, but I know that the community meeting is defined specifically in the contract. As a public meeting. Item 1616 concerning access to meetings and records reads, quote, by executing this agreement, the grantee agrees to open its meetings and records to the public. And then in Appendix A, item 4C3, they're required to hold regular, well-publicized monthly community meetings with participants. So a community meeting is a public meeting, and I think that's all the protocols of a public meeting are required, such as minutes. So if they don't have this document, then I think they might still be not in compliance with the ordinance because they don't have, they haven't kept any record of this meeting. They haven't kept any minutes. Thank you.
Okay. Thank you. Oh, I'm sorry. Mr. Weston, you were quoting from the contract, the St. Vincent de Paul contract?
Yes.
Okay, can we see a copy of that?
Yes, if I can. I haven't.
If you haven't.
Again, I didn't know we were going to
Okay.
discuss it, but I have a copy.
Take your time, there's no rush.
Could I ask a point of clarification? Who is this complaint against? On page 41, it says Department of Human Services, and on page 43, it says the St. Vincent de Paul Society.
As I mentioned in my prior comments, the complaint itself is against St. Vincent de Paul, and we voted on jurisdiction under 12L, therefore.
So on page 41, it should say Paul Weston versus St. Vincent de Paul Society?
Yes. Correct.
Okay, got it.
That was a mistake.
And you said you determined they were legitimately a 12L for our purposes?
No, what I said was, did the chair of the complaint committee agree that we have jurisdiction under 12L? And he said yes.
Okay.
Is a representative from the Department of Human Resources here? Human Services, sorry. The matters with the task force for discussion and questions. Okay. Is the representative from the St. Vincent de Paul Society here? Hey, Chris, can you go get that document for Mr. Weston? Thanks.
Mr. Weston's correct. It's been neither the custom and practice for the over 10 years we've operated MSC South, which is a program of St. Vincent de Paul, to keep minutes of community meetings. I don't generally attend community meetings as the executive director. No board members attend meetings. These are community meetings meant largely for the clients. When I inquired to see if there were records, my program director said she did take notes on occasion, but she didn't keep them. So I have no records to give Mr. Weston. I'm not aware that there's any statute or legal authority that requires us to keep records of a community meeting in the homeless shelter that we operate. Under this subsection L that I've now become somewhat familiar with, I read it to require us to provide our audits, our budgets. Certainly, I gave Mr. Weston the contract and copies of our invoices because I think that's part of that, even though it's not spelled out. But I don't have records. And if you guys want to tell me to start taking minutes, I'll be happy to bill the city for a stenographer or a court reporter or a tape recorder. But it's never happened before. Maybe it should, but that's not been the case, and I don't think there's any legal authority to punish us for not having done so in these community meetings.
Great. Thank you.
I have a question for Ernie. Ernie, under their category as a 12L entity, where do they fall on the question of minutes of a community meeting?
Community meetings don't fall in this section. Board of Directors of meetings of a 12L, at least two of them must be public and open to the public. But this is not what is requested. This is not what we're talking about. Community meetings are internal service meetings with clients, and that's not covered under 12L.
Okay. Thanks.
So I think what we're left with is does the contract that the St. Vincent de Paul Society signed with the city require additional activities from the St. Vincent de Paul Society?
The copy of the contract that we just received simply repeats 12L. It doesn't add any additional requirements.
Yeah, it's 12L.
I mean, the idea here is this meeting a policy meeting with policymakers from St. Vincent de Paul Society attending and making decisions? I think that's what we have to decide. And from what I've heard, I don't think it is. I think it's a service meeting with clients, program directors. So I would be inclined to find to take no action on this.
So in this part of our process, sorry. please.
Having looked through 12L, I don't see the kind of minutes requirements here that are contained in the Sunshine Ordinance. I think if the St. Vincent de Paul people want to keep minutes, I would certainly recommend it, if for no other reason than to have something to go back on in case there are questions as to what actions you took, et cetera, et cetera, et cetera. It's always, it's always good to use as a reference. However, I don't think this task force could order you could order the society to keep minutes. The notes that the complainant referred to, I don't think they fall under that kind of a category, and they're not available. I mean, they were personal notes taken, and then for whatever reason tossed in the can. So I really don't see a violation here.
I have a question for the society. We're kind of speculating on the nature of these client meetings. Could you typify those meetings for us? What goes on, the formality, what they're set to do?
Yeah.
Are they determining policy, or is it a meeting amongst clients?
I've attended a total of 2 in the 2 years I've been executive director, and I attend them largely to be supportive of the program director. No board goes there. No officers go there. I'm there to support my program director and some staff who have a custom and practice that should be done and is done to meet with the community every month or so to hear complaints and accept, advice and counsel and to tell them what's happening. For example, our contract was renewed. There was lots of discussion in community meetings about that. Changes in the shelter system. I have to. Mr. Weston is. I want to say he's a bright, articulate, intelligent person, and I respect a lot of what he's doing in his process to open up the system. That's legitimate. Some of the things that I do have a problem with are that, he was denied service at the MSC by an arbitrator, a third-party neutral arbitrator, and I'm afraid that some of this is motivated by, upsetness.
Well, we don't look for motives here. We just go by the facts. But thank you for your answer.
Those
You
are the
answered my
facts.
question. Yeah,
Thanks.
But I'm not. I agree with 2 of the previous speakers. I'm not seeing a violation here.
Great. As part of our process, the respondent and the complainant both have additional time if they'd like to take it. Is there anything that the DePaul Society would like to say?
We have nothing to add.
Thank you. Mr. Weston, would you like another 3 minutes?
Yes, this is a policy meeting. Appendix A, item 4C3 of their contract, I can cut this, not in this copy, I can make another copy for if you need, but it reads under their description of services, I believe, C3 reads, hold regular, well-publicized monthly community meetings with the participants. These meetings will focus on participants' concerns about shelter operation and participants' recommendations for procedural and or policy changes. During this meeting, the grantee will distribute client satisfaction survey forms and for participants to complete and return. So this is a policy meeting, as defined in their contract. The meetings that are conducted now don't really fall, don't really comply with this obligation, but it's defined in their contract to be a public meeting where policy is discussed. And this is a publicly owned facility that they're operating. And so, yes, I find it hard to believe how this is not a public meeting where minutes should be kept.
Thank you. Mr. Luente, can you give us a short description of what the Sunshine Ordinance means as when they talk about policy meetings?
I think that under 12L, policy as discussed and determined by a policy body is what's intended by 12L. I think what I'm hearing is that this community meeting will bring up subjects, one of them being policy, which I believe will be recommendations that may go to a policy body, that is the Board of St. Vincent de Paul, who may then take action on any recommendations that may come out of a community meeting. But I don't think the community meeting itself is a policy body or is making policy. I think it's an informational meeting, information gathering meeting, which can produce recommendations that could be helpful to the policy body. But I don't think it falls under 12L, even under that analysis.
I just wanted to make sure Mr. Weston understood what we mean when we're talking about these meetings.
I don't actually see where policy is mentioned at all in 12L. Am I missing it?
He said he has another part he has it from the contract. It wasn't from the 12L.
Right, but the contract requires them to have community meetings where they discuss policy and complaints. That doesn't turn into a policy body unless it's covered by 12L.
Exactly.
I don't see the word policy in 12L, or I don't see 12L hinging on whether or not minutes have to be taken, depending on whether the meeting at issue under 12L is a policy meeting. It requires a minimum number of meetings where the board of directors are in attendance, that they be public, and that they allow for public comment, and then there's some other disclosures regarding financials and et cetera records. Mm-hmm. But I think we're a little bit off track here on this discussion of whether or not policy is discussed at this meeting. That doesn't matter to the ultimate outcome.
I mean, I think it hinges on if it's recommendations or if people are making decisions on policy. You don't think so? I do.
Is there a motion?
I move that we find no violation.
Second.
Is there any public comment on this item? Seeing none, can you call the vote, please?
On the motion, Member Craven Green. Member Craven Green, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knepper.
Aye.
Member Knepper, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, excused. Member Chu.
Aye.
Aye. Madam Chair, we have 9 ayes.
Thank you. Can we call number 7, please?
Item number 7 is determination of jurisdiction on complaint filed by Hannah Leung and Lydia Fong against the Department of Human Services for alleged withholding information.
I move that we find jurisdiction on this item, members.
Second.
Is there any public comment on jurisdiction? Seeing none, can you call the vote, please?
On jurisdiction, Member Craven Green.
Aye.
Member Craven Green, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knepper.
Aye.
Member Knepper, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, excused. Member Chu.
Aye. Is there a representative? Thank you. Is there a representative from the Department of Human Services here? Seeing none, we can go ahead with this complaint. They're not here, so it leaves us at a disadvantage and as we talk about this complaint. But unless there's any concerns from my colleagues, I think we'll go ahead and hear this today, if you're willing.
All right, thank you very much, and thank you for members on the committee. My name is Hannah Leung. I'm one of the complainants, and my business partner, Lydia Fong, is in the audience today. This is a complaint regarding our application for the request for qualification 402 for real estate services for the Office of the Public Administrator and Public Guardian's Office. First, I would actually address the fact that Department of Human Services is absent today. When we filed our complaint in April, they were notified of the hearings in June, and for the entire month and a half, they did not oppose or object to the hearing time or try to contact our office to work out today's date. It was not until the day before our jurisdictional hearing in June that they faxed over a message and saying he would be out of the country or out of state and requested a continuance. But by that time, we have rearranged our schedule and our time we pay due respect to the hearing process and made ourselves available for today. So that's just to explain to you that they were given plenty of opportunity to arranged for today's hearing. We first filed for this request for qualification at the end of 2007 when it first came out for applications. After we submitted our application, and actually I have prepared a very rough timeline, and I have one copy. I do not have one for every member.
That's okay.
Would it be helpful?
Yeah, we'll have one.
Okay.
Pass it around.
So we first filed our request at the end of 2007 or the beginning of 2008. After we submitted our application timely, we were notified later on that the standard has been changed and that they would revise the standard and the new opening will be posted, and we would be actually notified by telephone of the next available opening application time. We were never notified. Nonetheless, we did apply for the next opening when it came up at the end of 2008 when the new standard was published. We submitted our application pursuant to the new revised standard. We were notified in March of 2009 that our contract, they have considered our application. However, they find that another real estate company, Keynote Properties, was more qualified for this position. And Keynote Property has been doing this position for the past several years without a contract. I then contacted Mr. Curdle on the telephone requesting a possibly meeting or just finding out more about this, the decision, and really to help us and educate ourselves in our future and knowing the application process. Mr. Curdle said that he would go ahead and arrange a meeting after our numerous phone calls. Then eventually he decided that we were not going to meet, and then he sent us letters informing us that eventually one letter told us that we actually don't even qualify. We did not meet the minimum qualification as requested in the standard published. And then we exchanged letters back and forth, and I wanted to see some of the files and the applications and all the discussion process. I thought that if I was told that there were 4 applicants and that they are all more qualified than we are, then I'm interested to see their accomplishment, their qualification, and actually also detailed notes and discussion involved in the process. Somehow the Department of Human Services never produced any documents for us. So eventually in April of 2009, we filed the complaint with the Sunshine Ordinance Task Force. About a day or two after that, Mr. Curdle did call and said, yes, I consulted with the city attorney and decided that we need to produce these documents, and we will produce those documents. We waited, and eventually what they have produced are just the score sheets, undated, but just score sheets with very brief notes on the 4 applicants. I gave a very detailed request, itemized request for the documents. So it's not just the score sheets. So when I requested for additional, he came back and informed us that the contract has not been awarded.
Thank you. We need to stop there so that each speaker has an equal amount of time. It's actually part of the Sunshine Ordinance. We do have an opportunity in our process for other parties associated with you that would like to continue speaking. If you're interested, if your co-complainant is interested in speaking for 3 minutes, this is an opportunity to do that. Or she can speak at public comment later in the process.
Okay. Would I be able to?
Because she's a party of the complainant. Okay, so this would be the opportunity if she wished to speak.
I will not be able to.
You'll have another 3 minutes later on to finish.
Okay. Let me just check with her.
Okay.
You want to talk now or later? Later? Yeah. Ms. Fong would reserve her right to speak later on.
No, I misspoke. Because she's a party to the complaint,
okay.
She can't speak in public comment.
She cannot?
No, she's not the general public. She's actually a party of the complaint.
Okay, so
So she can speak now for 3 minutes or not have the opportunity to speak.
okay. What do you think? Wanna do it? It's 3 minutes now. All right, so Ms. Fong will forego her
Okay.
right to speak at this time.
Thank you.
Thank you.
I'll ask one more time. Is some representative from the Department of Human Services here? Seeing none, the matters of the task force for discussion and questions. Members? Please.
Well, this one is more disturbing to me because this is definitely one where I have a lot of questions for the Department of Human Services and what they provided, what they can provide. So I have a lot of problems with this. I don't know what to do. I mean, absence of being able to ask them the questions, I have to find that, I mean, there is a violation, but I just don't, I feel unsettled because I have a lot of questions to ask.
Right.
May I ask a question of Ms. Young, please? Yeah. So when was the first time what was the date of the first time you received a written response, or not a written response, but documents in response to your request?
The first time we received was a letter from Mr. Curto dated March 3rd, 2009.
No, not with respect, let me rephrase. When was the first time you received a document in response to your
To my
request,
request,
for public documents?
That would be June 09, a few weeks ago.
Was it after you filed the sunshine complaint or before?
After we filed.
So the only time you got documents was after you filed the sunshine
Yeah,
complaint?
it was after we filed, and that was what we got. The score sheets.
Right. The undated score sheets.
The undated score sheets.
So you received the score sheets. Did you receive the names of the scores?
Initially, I did not receive the name of the scorers, and no, actually, let me back up one more time. The first time I received was not the score sheets. The first time I received was a letter from Mr. Curto outlining the scores. He summarizing the scores from the various selection committee members in his letter, and also they were named as reader A, B, and C. Upon further request for production of the names of the scorer, then I was given the names and also the score sheets.
Okay. And just to confirm, has this contract been awarded as far as you are aware?
As far as I am aware, it was awarded on March 3rd, 2009, when he sent us a letter to say that we are not selected for the position and that they found Keynote Properties was named in the letter, yes.
Right, but that means they've selected, the department has selected someone, selected a candidate, but I believe that in Mr. Curto's written response, as you state here, Mr. Curto sent a written response stating that an award would not be made until the selection committee meeting of July 1st, 2009, because it has to be approved by a public body.
Well, and this is the reason why I would like the production of the documents at this time. We were never told that the contract has not been awarded. I've been led to believe the contract has been awarded, and that's the reason why we have the back and forth regarding this. Had he just said the contract has not been formally awarded, I can produce everything except all the 4 applications, I am reasonable, I understand, and I would say, fine, and we will make arrangement for that. But that's not what we were led to believe. And I feel that the production of the entire process should be made transparent and public at this time, since we were told one thing, but then it was something else. It was first that you are not qualified, you're not the most qualified. We found someone else more qualified. Upon further pressing, then we are not even qualified. Then you should have returned my application if I don't even meet the threshold standard. And when
Thank you. Thank you. That answers my question. I don't have any further questions. Okay. The issue is under Section 6724E1 that as soon as the review or evaluation of RFPs has been completed, certain subcategories of information should be produced. Evaluation forms, score sheets, documents used by persons in the RFP evaluation process, names of scorers, graders, or evaluators, along with their individual ratings, comments, score sheets, or comments and related documents shall be made immediately available after the review or evaluation of an RFP has been completed. It sounds like that's been done. So those documents should have been produced soon after April 29th, which was at the latest the first time a detailed request was made. So those should have been produced. It sounds like some subset has been produced, but not all, to be honest. I mean, that's why we need the department here to figure that out. So there's been at minimum a violation. With respect to the other documents, which include the applications and communications and negotiations between the city and the people who submitted the RFPs, those can be withheld, quote, until they shall be open to inspection immediately after a contract has been awarded. And under general parlance, and DCA Lorente can comment on this, that is at the point that it is actually voted on and approved by the policy body who has jurisdiction over the contract. It's my understanding from Mr. Curto's correspondence that has not happened here. Whether or not the department, whether or not the respondent in this instance has misapplied its criteria in the RFP selection process is not something within our jurisdiction. We can't say you made the right decision, the wrong decision, you misapplied your criteria.
I understand.
That's not within our jurisdiction. Our jurisdiction is only about release of documents that we consider public. Under my analysis, it seems like there has been a failure to provide what should be produced at this juncture. I'm also of the decision, though, that we should continue this matter until next month to hear from the department. They have notified us they couldn't attend. They've notified us for a long time. Unlike the last complaint, Mr. Curto, who has been involved in this process and in doing the correspondence, does seem the person with firsthand knowledge about most of this, the factual background here. So the fact that he cannot be here because he is out of state would lead me to request that the task force approve a continuance and that we hear this again next month to figure out whether or not there was substantial compliance.
If that's the motion, I'll second it.
There's one other point, too, that I want to raise, and I raised it in my memo. 67.25E1 deals with requests for proposals, RFPs, which were in common terms, meaning we're asking you to propose to take on a job. This is a request for qualifications to see whether you're eligible to do a specific task. I think there's significant parallels to it, but I'm not exactly sure if it's exactly the same. And I would have liked to have Mr. Curto here also to explain whether or not he believes that it does fall under this section or not. And that's another reason why I think it's important to have the department here.
So if I may ask Member Nee for his recollection, I think that's an excellent point. My recollection, and I could be very much incorrect, we've revised, the task force has made proposed revisions to this section to make it clear that this section covers RFPs, RFQs, and certain numbers of the other types of procedures which the Department of Contracting engages in. We had testimony from the department when doing those revisions, and I believe, if I'm not mistaken, and this is why the department would be helpful to have them here, that they testified that they apply this provision, or these provisions, to RFQs as well, in the same manner. The request for qualifications, information is produced after it's been reviewed, but that the proposals and applications are withheld until an eventual contract has been awarded. But there are some differences. I mean, and I invite Member Nee to, he may not have any specific recollection about this, and mine may be wrong, which is another reason why it'd be helpful to have the department.
My recollection on it is very cloudy, and I would have to go back and look at the amendments package before I could really render any kind of authoritative judgment on that.
Okay, we'll talk about the continuance in a little bit. And this part of our process, you have another 3 minutes if there's anything additional you'd like to provide.
Then my request would be, at this time, since the last RFQ in 2007 has been passed, and I believe that we should at least be provided with a copy of the file of the previous RFQ that's been pulled off so that we can see the applicants in that RFQ and also the correspondence associated with it, discussion on the new standard revision and the rationale for the standard revision. And also we request at this juncture, and I just would like to comment at the very end, and I understand that I very much like Mr. Curdle to be here. It was frustrating to deal over the telephone and with correspondence and so forth. But having him send us a faxed letter the day before a hearing to say he cannot appear when he had ample time to plan his schedule, to notify us, and plus also the fact that he could have notified us of the reason why he cannot produce the application instead of saying that he can produce the application. I feel that the production of the documents now might actually enlighten parties involved as to the reason for the delay and why we are not provided with all these copies. And I'm also requesting that at this time, besides the score sheets, all the other documents eligible for production should be produced at this time, and I don't know whether it's within the committee's power to order, but however, we have requested all facsimile communications, even telephone messages, and I just would like to see calendaring entries when people are calendared to meet to discuss routing slips where documents were routed from department to department or to the various readers. An assignment and all those that I believe at this time would not jeopardize the selection contract that should be awarded at the end. And he indicated that the meeting would be July 1st, so it would be in 2 weeks.
Great. Thank you.
Thank you.
So from this continuance standpoint, I think what we're arguing is that it sounds like there's a violation, right? What kind of testimony would cause us to find not a violation?
That RFQs have not been treated as covered by 6725
E1.
E1, 24E1, which specifically identifies requests for proposals only.
If they convinced us that RFQs
The ordinance is pretty specific, but it's my belief, but I'm very cloudy on this, that they've treated RFQs and other requests that the Department of Contracting has in the same manner. But this ordinance itself does not specify.
Right.
It just says RFQs. RFPs.
So they could come in here with the city attorney saying the city attorney is arguing this side, and we would.
No, they could come in here and say our policy and practice is that we don't believe that provision applies. We've never complied with it.
May I use my first 5 minutes on the jurisdictional? I have not spoken
No.
on the jurisdictional.
No. Okay. What was there? There's a motion? Motion to continue. Is there any additional comment?
I would say just that it seems that in the testimony today, there's been references to additional requests that aren't in our packet. The only thing in our packet is the written request of April 29th, and that's really much narrower than some of the documents that were referenced. So if you haven't made specific requests to encompass the other documents you're interested in, do so.
I don't think there's been a motion.
Erica, do you want to formalize your motion?
I think it was a motion for continuance, and Member Coffin seconded.
Yeah. Is there any general public comment on this item?
I've reviewed some of the documents in this matter, and it really kind of seems a bit strange to me that we're going to continue something that effectively is going to be decided on the 1st of July, which by that time is going to be too late for the complainant to have the documents necessary to appear at that hearing and make appropriate comments and ask appropriate questions. What is the city budget in the situation right now? Well, we're about $500 million in the hole. and a lot of decisions are being made. And I think getting the public really involved in this process, for whatever reason they choose to do so. If I'm a citizen and I feel that something's not being handled effectively or correctly or whatever, I should be able to look into that. And I should be able to get access to the documents necessary to answer the questions that I, in my mind, have raised. If I'm going to appear before a public policy body and I'm going to make comments that I believe that you should or should not approve a contract, if I can't see any of the documentation or the terms of the contract or the qualifications of the people involved, although the recommendation is now going to be made, how am I supposed to intelligently comment on the fact that this was not handled? Now, there are going to be certain things. If I'm a contractor and I put in a bid for the city for a contract, I should be able to see all the documents that everyone else submitted for that contract to determine whether or not they made a legitimate bid, whether there were factors that they didn't meet in the qualifications process. Getting a letter, as I've seen in this particular case, saying, well, you just didn't meet this one qualification, therefore you're out of the running, doesn't answer the question as to did the person who you are now leaning toward meet those qualifications, or did you simply find one little thing and say, oh, there's one that I don't meet? You know, the bottom line to open government is people ought to be able to look, and there shouldn't be anything to hide. If they are doing this process in an open and fair way, they should be willing to show all of the numbers, all of the RFPs and whatever it happens to be, so that a citizen or a contractor can look at it and make intelligent comments. You know, if I'm a citizen and I show up and they give you this big 60-page long document, how am I supposed to make a comment on it when I haven't got any time to look at it? In this particular case, I think it's really egregious in the sense that they haven't got the documents they need. Now you're going to talk about continuing until next month, where it's after the fact. It's too late to do them any good. And it's too late to do any other members of the public who also might want to make comment on the same matter any good. So it's a little shell game where, let's keep it hidden until it's too late to do anything about it. And then after the fact, what have you got? A handful of nothing.
Thank you. Is there any additional public comment? Seeing none, if there's no other member comments, we'll have the vote.
On continuance, Member Craven Green.
Aye.
Member Craven Green, aye. Member Nee.
Reluctantly, aye.
Member Nee, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
No.
Member Knebber, no. Member Johnson.
No.
Member Johnson, no. Member Chan.
No.
Member Chan, no. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, excuse. Member Chu.
No.
Member Chu, no. Madam Chair, we have 5 ayes and 4 noes.
Thank you. Are there any additional?
It's a procedural motion, Member Nee, isn't that correct? A request for continuance is procedural, therefore simple majority.
What was the vote count?
5-4. 5
Okay,
ayes.
so it passes?
Passes.
Okay. We will hear this matter again at our July meeting. And as Member Craven Green said, if there's any additional documents you want, this would be the time to ask for them, because we could also have that as additional information for that meeting. Thank you, ladies. It's time for number 18, public comment for items not listed on the agenda. Is there any public comment for items not listed on the agenda? Is there someone here from New America Media?
I believe that was what.
This would be the time to talk. Thank you.
Hi, good afternoon. My name is Sandy Close, and I'm the director of New America Media. And I have several colleagues who came with me this afternoon to observe the very important role I can see that the Sunshine Task Force plays. And over the last several days, we've been made aware of our missing in absence, missing in action status, both by members of the Commission and by members of the public. And we're very grateful to have our attention drawn to the fact that we've not had a representative here. We definitely do believe the Commission plays a very important role. We've surveyed members of the ethnic media who over the years have volunteered and then found themselves unable to remain consistent representatives. So as an alternative, we've drawn on members of our staff, many of whom come from ethnic media and can provide that perspective. What happened was that when one staff member agreed to replace Ketiki Gokali, who was our last representative and who went to India for the Wall Street Journal, could no longer participate. There was confusion, and I have to say I am largely to blame for letting this matter fall off my radar. I work 7 days a week, and somehow I just wound up being oblivious that we were missing this very important responsibility. So I wanted to apologize. We came as a collective group to ensure that the person we nominate to take this position, this very important responsibility, really understands what is required, and that the person we nominate is fully prepared to undertake it for a lengthy period of time. We also, though, wanted to say, look, we screwed up. We made a mistake. We do not want to be a hindrance to the work of the committee. And I think if they're very attentive members of the public, very concerned groups that feel the position we have taken would be better delegated to them or to somebody else, we want to say whatever we can do to make amends for not having been here for the last 6 months, whatever you decide, we are very anxious that ethnic media be represented, have a voice. We know we have their support as their representative. We will certainly discuss this seriously in the staff and come up with our best recommendation.
Great.
We also, though, really want to say we will abide by your decision if you want to continue to have us, and we will amend. I will amend my ways, which I really do apologize for, and I take it on me.
Thank you.
Okay.
We look forward to working closely with you. The decision about New American Media is actually made by the Board of Supervisors, and it's actually in the law. So you are our source of a representative, and so I think it's going to work out really well. I really appreciate your thinking hard about which person would be the best representative for this organization.
We did have a question, which is it a requirement? As you know, many practitioners in the ethnic media sector are not citizens and or might not be even permanent residents. They might be on H-1B visas, for example, for an extended period of time. So is there a requirement?
My city attorney suggests that no.
No.
I don't think there's no prohibition against that.
We will nominate somebody formally and submit it by the end of this week.
Great. Thank you very much.
I do apologize, and I appreciate the public call to action that I got over the emails. Okay.
Thanks so much. Is there any other general public comment? Seeing none, can you call the next item, please, Chris?
Item number 9 is the determination of jurisdiction on complaint filed by Alvin X against the Office of Economic and Workforce Development for alleged failure to respond.
Members, I move that we find jurisdiction on this item.
Second.
Is there any member comment? Is there any public comment? Seeing none, can you call the question, please?
On jurisdiction, Member Craven Green. Aye. Member Craven Green, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, excused. Member Chu.
Aye.
Member Chu, aye. Madam Chair, we have 9 ayes.
Thank you. Is Mr. X here?
Yes.
You have 5 minutes.
Okay, on jurisdiction, that's a determination, and on the hearing, I just got what amounted to a several synopses.
This is on the merits of the case.
Yes.
Okay, great.
Item number 10. Just got what amounted to several summary synopses of my request to the Department of Human Resources. Initially, I made a verbal request, and I did not at this time.
Excuse me, he's talking about the next one, not
Oh, are you still on 9? Jurisdiction?
This is against the Office of Economic and Workforce Development,
the Mayor's Office, Workforce Development.
not the Department of Human Resources. Does that make sense?
You filed 2 complaints.
The one I have says Office of Economic and Workforce Development.
Yes.
Yeah, that's the one where initially I made a verbal request. I admit I was a little lax. I didn't follow through with an email or a letter per usual. However, the law states that a verbal request is sufficient. And they sent, again, not what I requested in total. And I, under the provisions of the Sunshine Law, I demand that information in total. I need the data to disprove and prove.
Great. Is there any additional information? On this
I'm pretty sure
item?
that's sufficient.
Thank you.
Is that sufficient for you?
At this time. You'll have another time to
Okay,
speak, too,
all right.
if you feel like it's
Yes.
missing. Are there other parties of the complainant wishing to present facts and evidence? Seeing none, is there a representative from the department? You have 5 minutes.
Hi, I'm Christina Pallone. I am the Executive Assistant to the Director of Workforce Development, Rhonda Simmons, and I did receive a phone call from Mr. Zex requesting the information that you see, I think, in your packet. At the initial time that he made the request, I was unaware that I was under the impression that we had to have a formal request of the information. I have since found out from our city attorney that he was indeed correct, and we did provide the information on June 1st to the Sunshine Task Force across the hallway, and that's the actual documentation that I think is included in your packets. If not, I have
Yeah, it's a
few
single
packets.
page.
Yes.
Yeah, we have it.
And that's the information that I received the formal request in writing on the 26th from our director, Michael Cohen, through my director, Rhonda Simmons, and we responded within the 5-day period on, June 1st, addressing Mr. Zek's requests for information on the specific details that he had requested. Is there
any additional information?
No.
Thank you. Is there anyone else from the city that wishes to respond? Seeing no other matters with the task force for discussion?
I had a question for Mr. Zex. So Mr. Zex, you simply made an oral request back in was it back in May? Was it?
I believe so. Yes.
And then did you after you filed the complaint? Then you got the documents, correct? You filed the complaint on
I
June
believe
1st,
I got
right?
an email attachment with. I got an email attachment with, again, what amounted to a summary. It didn't answer all of my questions.
Did you get all the information you asked for?
No.
What didn't you get?
I needed specifics, numbers, and a breakdown of ethnic groups, any ethnic groups receiving services or monies.
Is that what you asked for? Because you didn't see the problem when you make an oral request is that there's no record of what you've asked for. So if you could follow up with a request for the breakdown that you want, then they will have that in writing, so they will know exactly how to respond.
Yeah, I want to request a continuation. I admit I didn't give details as I usually do. So I make a request for continuation to give them a request in a letter or email. Because, again, there could be some confusion with a verbal request on a recording. There was a recording made, I believe, of that on both sides.
Right.
But I will ask for continuation to make a detailed request.
Okay,
Because I
think-
was a little lax. I didn't follow through with an email this time.
Because I think that there was an untimely response.
Yes.
But regarding the material, she did give you a lot of material that is pertinent to what you asked for. Now, if you needed a more detailed breakdown, then, as I say,
Yes.
I'm glad you're going to put that in writing so
Yes.
that they can follow through in
Yes.
that. And could I talk to Ms. Christine, I think your name is? So apparently, Mr. Zex wants a more detailed breakdown. So if he puts that in writing, then you're equipped to go into your files. And do you find any documents you have that would show a more detailed breakdown?
If we do keep that information, yes, we can provide that information. But if we don't keep it, we're not going to be able to get the specifics. But whatever we have, we definitely will give him.
Okay, good. Well, thank you.
Thank you.
And
I just have one question for you. Did you ever send this information to Mr. Zex, or did he get it through the task force?
He got it through the task force because in our initial conversation, it was somewhat heated, and he hung up before I got a chance to get his contact information. And then the email that I received from the Sunshine Task Force blacked out his address and email address, so I could not contact him directly.
So he never left you information of where to send the information?
No.
Okay.
No.
And through the chair, I just wanted to follow up to make sure that you fully understand now that oral requests
yes.
Are legitimate under the ordinance and have to be responded to if they're an IDR by the close of the next. Actually, IDR should be in writing, but within 10 days.
Yes, okay. I am fully aware.
As soon as possible, but no later than 10 days.
Right, correct. Thank you.
Right. So, and Mr. Zex, you will give her your contact when you make your request. You will also give her your contact information.
Well, I'm pretty sure I left 2 phone numbers and an email address. However, again, I'll make a request for continuation, and I will make sure that they get at least 2 phone numbers and 2 email addresses.
Because they need to know somewhere where to send this stuff. So if they can email it to you, that's great. If they have it,
I'll leave
or a fax number.
residence and an email address and a phone
great.
number. So I don't think anyone will have any trouble contacting me.
Okay, great, good, thank you.
Thank you.
Please. Well, I would like to move a violation because of an untimely response.
Okay. We'll actually get back to that in a couple more steps on our process. Member Nee?
I'm not sure a continuation is necessary here. Mr. X has acknowledged that the information he provided to the respondent agency was incomplete and that he should have followed up. What I would suggest is that we just take this off the table, period, and if Mr. X does not receive the information that he wants within a certain amount of time, he's welcome to file a new complaint.
Yeah, that was my understanding. I wasn't quite sure what he meant by continuance, but my thinking would be that we should do an order of determination on the matter at hand, and if it's the further contact is not satisfactory, Mr. Zex can file a complaint. But I think it's very clear that the department made a mistake. It realizes it made a mistake, and we should let it go at that.
As part of our process, the respondent and the complainant have an additional 3 minutes if there's anything you'd like to clarify. We start with the department. Do you have anything additional to say? Thank you. Mr. X, do you have anything additional to say?
No, thank you.
Oh, there you are. So I'm confused. We don't have a motion?
Madam, I
Is that where we're at?
move that we find that there was an untimely response.
Violation. Okay, I would support that. Forward it to the EOT committee, and then at that time you can have a discussion on whether the other documents were produced. That seems like.
I'll second that motion.
Okay with me. Okay.
Does that sort of fit in with everything I
Fine
was
with
thinking?
me. We're very happy to come out and make a presentation to. We had a very satisfactory presentation yesterday at a group, and we're very happy to come out and make a full-blown presentation on the Sunshine Ordinance, and we're very succinct, and we're quite interesting, we were told. So if you're interested, give us a call.
I actually would think this is, because this is an issue of untimely violation, and there's an outstanding issue as to whether all the documents requested have been provided, as opposed to an issue that deals more with ongoing obligations under the Sunshine Ordinance, that it would be more appropriate to refer to the Compliance Amendments Committee, not to the EOT. So I would support the motion with that proposed amendment through the chair.
Okay. Who made the motion?
I think I think that when the Compliance and Amendments or the EOT committee was reformulated, one of the things we were thinking about was that we would try the carrot rather than the stick. I'm happy either way, but we've had some very good results with people. We thought we had some good results with the police department. Lieutenant Mahoney is here today, and he can testify to that. But we certainly had some good results with the HIV Care Council, because I think that sometimes departments they truly don't know. Maybe they don't take the time to find out. But I think that the city attorney's office no longer has these massive education and training sessions, which I wish they would still do, because then there's at least somebody in the department who knows the rules. So I think when it comes before the Education and Outreach Committee, we do have an opportunity to work with the department and make them aware of all the important items in the Sunshine Ordinance, and if it still doesn't work, then it can go to the Compliance and Amendments Committee. That's kind of the way I see it.
Okay, why don't we leave it at EOT for one meeting, and then if it doesn't work out, forward it back.
CNA, if CAO.
Yeah, I'll forward it to CNA.
If it doesn't.
Is there any general public comment on this item? Or any public comment on this item?
Again, here we are 10 years down the road, and we still have members of the city government coming in here and consistently saying, I didn't know, I didn't know, I didn't know. Now, if you walk into a court of law and you say, well, I didn't know it was against the law to do that, what are they going to say? Ignorance of the law is no excuse. And yet they'll walk in year after year after year at hearing after hearing after hearing, and the answer will be, well, we didn't know. And then it's like, well, we'll send it to education and outreach because, and I'm going to get into this a little bit, because it's better to use a carrot than a stick. Well, bottom line is, if it's not working, carrot or stick, neither one is the answer. And what I see continually is people who show up from the city who use the argument that we didn't know we were responsible under our law that has been in existence for 10 years to do certain things. We didn't know we're supposed to keep an index of records. We didn't know we're supposed to have a custodian. We didn't know we're supposed to have a telephone number. We didn't know we're supposed to respond. We didn't know where we're supposed to respond. I mean, for heaven's sakes, at what point does someone say, it's your job? You have a legal responsibility. And it's one of the reasons that I've said time and time again that some of these questions, especially for non-attendance, should go directly to the department head, the person who signed a legal document stating that they knew the requirements of the law and they knew that their responsibility as head of a department was to ensure that the law was being followed and that employees under their direction were aware of the law and were following the law. But for some reason, we talk to the low-level people who really, in the day-to-day shuffle, are not going to have that knowledge, instead of to a department head and the senior people who are legally responsible for knowing that this law exists and for knowing what the requirements are and ensuring that their people are trained in this. They should be coming to you saying, my people don't understand, we've had this and this and this go on, we obviously need some training, will you come and train us? And how many of you want to hold your breath till that happens?
Thank you. Is there any other additional public comment? You can't comment on your own matter. Oh, no, this isn't general public comment. It's a public comment specifically on this issue. Yeah, thanks. Any additional public comment? Seeing none.
Madam Chair.
Yes.
I move to amend the motion on the referral to send it to compliance and amendment.
Who is the maker? Sue, I believe you were the maker.
I did. What's the motion?
To amend the original motion to refer to compliance and amendments rather than to EOT.
Is referrals part of the order determination? Maybe I shouldn't have actually.
It actually, I think it is now, because we have now stated in our procedures that it's EOT or CAC as being one of the bodies that will follow up. I think we've tried to make it clearer as that this doesn't end here. It will go to a committee. And so our procedure, at least up until maybe March or April, we decided to send it to a committee, and I think you should specify.
Well, what does it say?
The motion specifies EOT.
1 second.
Yeah.
What are the procedures, the current operative procedures say?
We're trying to, Rick, we're trying to figure out whether it's at the discretion of the chair or whether it has to be determined in the previous to this.
The motion I believe calls for referral to the EOT. If the second and the maker would like to withdraw that portion of the motion, then I can support it.
I think referral to the EOT is a good thing to do, because not only does it, as I said, provide a carrot to the department rather than a stick, it also gives us an opportunity to enunciate the Sunshine Ordinance to a lot of people we wouldn't reach otherwise. So therefore, I would not accept the friendly amendment. And my position would also be...
Excuse me, point of
position
order.
would also be that the chair has the right to send items to... The chair has the right of committee referral.
Point of order.
That's my opinion.
My motion was not tendered as friendly or unfriendly. It is a motion. If there is a second to my... The question is there a second to my motion?
I actually second it.
Okay, then the motion to amend takes precedence.
Can we have DCA Lorente advise us on this? I believe that the bylaws of the task force as amended say that where it is referred to is at the discretion of the chair. Therefore, it's something that can be in the order of determination but does not need to be, and even if it was, can, through the discretion of the chair, be amended and sent to wherever the chair would like. So that's my understanding of what the bylaws now say. I may be wrong about that.
No, I would agree with that.
Okay.
And I would also think maybe we should sever this. We haven't voted yet on the motion of violation.
We have not.
Huh?
We have not voted on.
Maybe we should vote on that, and then we should vote on, if we determine that the chair does not have the right of referral, then we should vote on where it goes. Can we do that separately?
We're being advised that the chair has that discretion.
She has the. I'm saying that under our current procedures, the chair has the discretion on referral.
So we still have two motions, right?
Well, okay.
One motion saying to CNA and one motion saying to EOT.
Let me amend. Let me reword my motion then, and that is to simply delete the referral section of the original motion. If the second to my motion will accept that.
Accepted.
Okay. So the motion now is to amend the original motion to delete any mention of referral, committee referral.
Can you call that question, please?
Right. And just to be clear, but the order of determination itself, if there's going to be a referral, will contain that, but that will be put in by the discretion of the chair.
Could we hear what we're voting on?
This is you made a motion that forwarded it to the EOT. And this is
I made a motion to find a violation.
Okay,
yes, and then forward it to the EOT.
The motion we're voting on now. The motion we're voting on now is whether to amend the original motion to delete any mention of referral to a committee referral.
Unless the original maker has no
fine
problem
with me. Fine with me. Let's just vote on the
Okay,
item.
is the second of the original?
Let's vote on the item.
Okay with it? Okay, so we'll just go with that. Now she created the original motion, and so she's taking out the EOT
I
part.
understand. We're just going to vote on whether there's been a violation.
Is
Okay?
that
That's
acceptable
cool
with
with
the
me.
second of the original motion?
Yes.
it is.
Yes.
Okay.
So just to clarify a little bit further, are we talking about 6721B? I just want to make sure we have a number next to this one. Because it was a timeliness, right?
Untimely
Timeliness
response,
on
whatever
regular-
that
on a
is.
regular public records
Whatever that
request.
is.
Right, yeah, 10-day.
10-day
okay,
rule.
okay. Then let's make sure that says 6721B. Can you call the question, please?
On motion to find violation of 6721B, Member Craven Green.
Aye.
Member Craven Green, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, excuse. Member Chu.
Aye.
Madam Chair, we have 9 ayes.
Thank you. Can you call number 11, please?
Item number 11
Could I
is
just say
determination-
something before we go on as a point of something or other? Could Mr. Rustin be sure to add the Mayor's Office of Workforce Development to our July agenda of the EOTC?
Through the chair, yes, I'll do that.
I think that I think the party should be notified as far as any committee meetings following their orders of determination.
Yes.
That should be a standard practice.
Yeah,
All the
just
parties should be
inform both the committee, the Office of Workforce Development, and Mr. Zacks,
Is that okay to add your
the
procedures?
complainant and the
Whenever, thank you.
department.
Great,
Okay?
thank you.
Item number 11 is the determination of jurisdiction on complaint filed by Alvin X against the Department of Human Resources for alleged failure to respond.
Believe it or not, I move that we find jurisdiction on this item.
Let me just say, your packet does not have my amended jurisdictional letter, which I corrected, which I have handed out. And the department had stated, so hopefully that's now part of the record.
Thank you. Is there any member comment on this? Is there any public comment on jurisdiction of this item? Seeing none, can you call the question, please?
On jurisdiction, Member Craven Green.
Aye.
Member Craven Green, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon. Aye. Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, excuse. Member Chu.
Aye.
Member Chu, aye. Madam Chair, we have 9 ayes.
Thank you. Mr. X? Is there a representative from the department here? I guess we'll just go along with 5 minutes. I guess nobody has any idea where Mr. X just went?
I went outside.
Yes.
Before hearing from the city, I believe the chair might want to ask if there is anybody here to give evidence in support of the complainant.
Is there anyone in here that would like to give evidence in support of the complainant? Seeing none? You have 5 minutes.
Good evening, Task Force. My name is Paul Green from the Department of Human Resources. We're not contesting our obligation here to provide the records. It's basically a dispute over the facts alleged in the complaint. Mr. X alleged that he made a request on May 8th. However, we believe that he first contacted our department on May 13th, where he left a voicemail to our director, Mickey Callahan's phone line, saying he would like to speak to her. However, he made no mention of a records request. The next day, Ms. Callahan's assistant, Jessica Williams, phoned him back. And then once it became clear he wanted to make a records request, he was forwarded on to Jennifer Johnston. And during that phone conversation, he mentioned that he would like our address where to send a request to, and that information was provided. However, during that phone conversation, he never made a request for documents, and if he had, we certainly would have responded because we get oral requests all the time, which we respond to. We did not become aware of this request or the complaint until we received it from the task force. And then during that time, we provided the response. However, his contact information was redacted from his complaint, so all the records were provided in our response to the task force. So we asked that no violation be found because we were never aware of the request until the complaint was filed.
Thank you, Mr. Green. Matters of the task force for discussion and questions. Please.
Well, it seems to me if we don't hear from the other side, we can't really make a decision here.
Well, and there doesn't seem to be any documents supporting
his.
We do have the complaint filed to us.
Right, the handwritten complaint.
Right.
Yes.
And I'm wondering if that suffices as evidence. He's saying that he made a request and he didn't get the information.
Well, I think it's evidence. I don't know how strong it is.
He may just be in the hall. Can we send Chris out to the hall?
Yeah. Well, you want to go see if he's out there? Thanks. Any other comments, please?
I don't know. It seems, and I'm not usually fighting for the city on this kind of stuff, but there's a lot of information here, and it looks like it responds to what he had asked for, what he says he asked for. So I don't think I would want to pass this up. I think I would want to make a finding of no violation. That's the way I would lean for this.
No. Okay. If the city has another 3 minutes, if there's anything additional you'd like to add, Mr. Green? Thank you. The matters of task force for a motion.
I move that we find no violation.
Second.
Is there any public comment? Seeing none, we can call the question, please.
And I would just like to point out that if this motion passes, if I may through the chair, and this isn't all the information that he requested, or there's some other factual discrepancy, he can bring another complaint to follow that up. So
He can make a new request. He can make a new complaint, whatever is
Right.
appropriate.
On the motion, Member Craven Green.
Aye.
Member Craven Green, aye. Member Nee.
Aye.
Member Nee, aye. Member Corbett. Member Corbett, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams excused. Member Chu.
Aye.
Member Chu, aye. Madam Chair, we have 9 ayes.
Thank you. We call number 13, please.
Item number 13 is the status of the orders of determination of Ray Hartz versus the Police Department.
Thank you. These items, I believe, were forwarded to the Education and Outreach Committee. Yes.
can you please speak into the microphone?
I want to recuse myself in this matter.
I don't know we're voting on anything.
No, but this is.
Still.
Okay.
I think that he can recuse himself because of a financial interest in that he is a patrol special, which has a contractual relationship with the police department. And
Okay. Unless there's any objection, you are recused. Can you tell us?
So we heard the matter twice. The problem was that the night that we heard the matter, the first time, we didn't have a quorum, and the Mr. Hartz was not invited. The Lieutenant Mahoney, who can fill you in when he speaks, said that they were giving this item.
Excuse me, can I raise a point of order?
No.
not. He doesn't have standing to make a point of order.
She's talking about the issue before the board before I've had a chance to present it.
You need to sit down.
So Lieutenant Mahoney said that the item had given, the department had given the item, they're working on the index of records, and they'd given it first priority, but that he did need, if I'm representing him properly, he did need to speak with the chief in order to get permission to follow through completely. We asked him back 2 months later. Again, we didn't have a quorum, so we called an informal gathering, which we were advised was perfectly legal. And again, Lieutenant Mahoney gave us an update, but he still had not fully complied with the posting of the index of records. That's my understanding. So we were going to hear from him again, but Mr. Hartz asked that it be sent to the full task force. Unfortunately, in neither case, when we did hear him in an informal gathering, had Mr. Hartz been notified. So he was only there at our last meeting. And so this is why it's before the full task force.
Thank you. Mr. Russum, we are now inviting all parties to committee meetings where there are items. Right. Okay. So what we're going to do is we're going to hear from the department and hear about the compliance with the orders of determination for 5 minutes, and then Mr. Hartz will have 5 minutes to discuss it also. Thank you.
Good afternoon, task force members, members of the audience. I'm Lieutenant Daniel Mahoney. I'm the commanding officer of the Legal Division. And today with me, I also have Lieutenant Joseph Riley, who's the Police Commission Secretary, as one of his matters is on with this as well. Ms. Cawthon is correct in exactly how the accounts or how things are going with it. I've been to the EOT meeting twice and gave them updates as to where we're going with that. Where we are is I have to deal with multiple agencies, if you will, before I can get this on the website or get the thing finished. I've had to deal with, when I first took this over after the complaint was held, we have a number of records that we did not compile because we've had updated records since the time this project started. So I had to go to a lot of the different divisions or units in my department to get an updated list of that, which I have now finally received. That list currently is sitting with the City Attorney's Office for review as to a timeline for the record destruction, which goes along with the index of records. Secondly, the Police Commission was found in violation earlier this year. I've asked Lieutenant Riley to provide me with an index of records, which he has done so. I then have forwarded that to the City Attorney as well for inclusion. The Police Commission is not a separate entity. They are under us completely, and they are all going to go on the City Administrator's website and the Police Department's website as one grouping of index of records. They're not separate. We did submit several points of records to the city administrator. I had my legal secretary submit that. It came back to us because it was not in the proper format, and they sent us the template with which to put it into the proper format that they want before they will put it on the website. We were going to send it to our webmaster, who I just found out we don't have one anymore due to budget cuts. So we are working on getting it on our website too. Once again, we don't do anything. I don't do anything without two approvals. One is with the chief of police, and secondly is with the city attorney. And that's what I'm waiting. And I'm waiting for a little bit. I've talked to both, and I've gotten some approvals from both, but we're just not there yet. The final piece to this puzzle is that since the complaint came in, I've lost 4 members of an 18-member office with no substitution or no replacements. My office clearly is doing more or less. That is not an excuse. That is a reality. And I have many, many job tasks in my office with many serious deadlines for federal court, for our state courts, and all the other matters we deal with. I'm not putting this on a back burner or anything. We are actively working on it, but at the same time, that is one of the major reasons for the delay. Just yesterday, I met with staff and discussing the Index of Records project, and we are moving forward. Not that we haven't, but we're starting to contact other people. So we are taking this seriously. It's just going to take a little bit of time.
Thank you. Mr. Hartz.
I filed 2 complaints. One was against the police commission, and we went through the whole argument about whether the police commission and the police department were separate bodies, and I thought we had that all settled. The first thing I'd like to say is that at the time both of these letters of determination were issued, your bylaws stated specifically that these shall be, the Compliance and Amendment Committee shall monitor compliance with the orders of determination. And I have heard continually this, we have the discretion. No, you did not. Your own bylaws tell you that you are obligated to send these determinations to the Compliance Committee. Now, you changed the law in April. That's fine. If you want to change things after the fact, then go back and say, well, we're going to now use the change we've made now to justify something we did earlier, I think that's inappropriate. One of the interesting things I noticed in researching this is complaint number 08056 against the San Francisco Police Department no longer appears on your website. There is no order of determination listed in either 2008 or 2009 under this number. So if you want to go check your own website, I don't know whether it's been dropped or what. And actually, I have the list here if you want to look at them. And I checked it this morning to make sure that was the case. Okay, so we had that one issued in January, another one issued in March. Then in February, there was a meeting, and apparently there wasn't a quorum, and therefore the decision was made to have a informal meeting. And your own bylaws, again, Section 7 say, if a quorum is not present, no official action may be taken except roll call and adjournment. Bottom line is having an informal gathering where members of the city agencies can give testimony, which is then entered as minutes into the record, is holding a meeting. Simply because if they enter testimony and at the end the chair or members of the committee say, thank you for coming, thank you for reporting, thank you for your efforts, it basically gives tacit approval to the actions that they have given. And I have read the minutes, and there would have been a number of questions I would have raised at that meeting if I had been invited, and as the complainant, I think I would be entitled to. In March, the EOT had a meeting, and in that meeting, for some strange reason, Mr. Lorente is giving reports about the things that they're doing, where he got this information, who he's having discussions with, and why they're discussing matters that I'm party to without anything, and then having Mr. Lorente give the EOT a briefing on the matter is questionable. Again, though, I was not invited, so I couldn't raise those questions then. Here are the actual minutes. DCA Lorente gave a briefing on the two complaints. Chair Coughlin and Lieutenant Mahoney came before the committee in February and said that the index was being given top priority. Well, it was an illegitimate meeting in February, and referencing it in here is just compounding the problem. Then in April, we had another meeting, still another no quorum, and still another informal gathering where, interestingly enough, the only two things that were heard in the informal gathering was a complaint I filed against the Arts Commission 09010, which at that time this board heard, found there was no violation, even though the agency said, yes, we're in violation, sent a letter that said they were in violation, testified at the hearing there was in violation. Now, interestingly enough, at that meeting, Sharon Page Ritchie of the Arts Commission said, oh, yes, we've corrected the problems. Well, one of you might like to go to actually look at the index of records and see what they corrected. They took out one line. What did they take out? They took out the one line for the document that I had requested that they didn't have. They have made no other changes. And then in June, I get a 24-hour notice saying, oh, we're going to discuss your problems tomorrow. What I'm saying here is that this has not been handled appropriately. You haven't followed your own bylaws. I don't know why my decisions here are apparently not being taken. If you want to use EOT to reach out to city agencies, there are probably 50 or 60 of them on the index of records, none of which meet any of the requirements of the Sunshine Ordinance. Why don't you take the ones that they aren't doing anything and I haven't filed any complaints about and take some action on those rather than hijacking the ones that I did? Now, I'll be very straightforward, and this is not attacking anybody, but I do not feel that the chair of EOT has made any effort whatsoever in this process to give me an opportunity to participate in the handling of the complaints that I fought for. And I think that is inappropriate. And the only way I got it before this meeting was I went before the EOT. I made a request that it either be referred to the other committee or to this board. And that was ignored. And the only reason it got here was finally I raised my hackles.
Thank you. Ernie, it seems like Mr. Hartz has two issues. One is the issue of process and one is the issue that's on the agenda. Do we have the ability to talk about process, given that this is agendized as a discussion of the orders of determination?
It's a status of orders of determination process. I mean, I don't know. I mean, you can. It is part of the complaint. I mean, it is part of the orders of determination in terms of what happened to the orders of determination following its issuance. So there is, okay. You can have some discussion on that.
Okay. I would prefer to talk about them separately, though, as an organization, because I think that the compliance with the order of determination is a very specific question. There's things we've asked them to do, and have they been done?
You know, we were talking on the last item as to, you know, when it's time for EOTC and when it's time for CNA. This might be a time for CNA. You know, I do regret that the two times that we heard it, we had an informal gathering rather than a full-fledged hearing, but we didn't take any actions, but we did hear what was going on. The issue is, though, that, we're still trying to work with the department, but the department has mentioned to us that there are reasons why they haven't actually moved forward. So this might be a time for the CNA committee to look into it.
I'd be happy to forward to CNA if we felt that they haven't moved forward with it in the time frame that we
I don't know.
think is unreasonable. I think that's what we're here to talk about.
I am convinced that Lieutenant Mahoney is doing everything within his power. His powers are limited, and we can order him to do it, and we can do this, and we can do that, and we can hang him by his toes. But if the chief doesn't give him the money, he still can't do it.
Erica,
Actually, I have a question for Lieutenant Mahoney on this point. When can we expect these documents? What is your best, realistic, but full out trying to comply and doing the best you can to comply estimate of when these will be posted on the website in compliance with the requirement?
Based upon the staffing I have now, I expect this to be done. I expect the format to be completed, sent to city attorney, and have a response and be sent to city administrator no later than August 1.
Thank you.
Question for Lieutenant Mahoney, please. Yes. Sir, you said you had to get approval from the city attorney and from the chief. Have you received that approval from the chief?
I have spoken with the chief about
Have you received the approval?
Okay. I have spoken to let me answer my question, okay? Don't interrupt me again, please. I have spoken to the chief regarding this matter. I have her approval to take the information, put it in the format, and take it to city attorney for their opinion. Once the city attorney gives me their opinion, then I will get final approval from the chief. The chief wants to hear from the city attorney.
You're about to get a new chief. Is that going to cause any further delay?
Don't believe so.
Are there any additional questions?
I would make a comment. My first comment is that I think the task force failed to provide Mr. Hartz with the notice that he was due in terms of this matter being heard at the EOTF, when it was being heard, how it was being heard. I think the responsibility to do that was both with the administrator and with the chair of the committee to find out why someone might not be at the meeting and had they been given notice. I think both of those parties have recognized that there was an error, and everyone on the task force is committed to making sure that doesn't happen and providing people with notice so that they can attend. So I expect that to be not an ongoing issue. It's been resolved, hopefully, but I did find it was unacceptable. With respect to Lieutenant Mahoney's time frame of August 1st, my concern about this was that it was dragging on. I wasn't getting full information about when it might be complied with or how it was being handled by the police department that was sufficient. I was concerned it maybe should go to compliance and amendments because of that fact. But based on what I've heard today from Lieutenant Mahoney, I'm fine with this issue remaining with EOT, and hopefully that will result in this being handled expeditiously, and as of August 1st we'll have the information that Mr. Hartz seeks and I think has been I would say spending a significant amount of effort to make sure happens. So that's kind of my opinion on it, is to maintain the status quo and keep up the pressure by EOTF on the department and the commission to have this information finalized and posted.
I would like to add that since Lieutenant Mahoney has given a no later date than August 1st, that's when it should be revisited to see where it is, if it's done, we need answers on that date. If it's not done, and why.
Yeah, thanks.
Through the chair, I would like to ask that the administrator put this on the agenda for the regular meeting in August of the Compliance and Amendments Committee.
Well, I think that where it gets forwarded is at the decision of the chair.
The chair of a committee has a right to calendar an item on his own committee.
Okay.
Kristen?
Yes, please.
I just wanted to say one thing, that I think that we do understand now that when a committee comes before the EOT, when a department comes before the EOT, that it's understood that the complainant will also be notified.
Yes. Thank
And
you.
I don't think really that this is the place to start pointing fingers at people, even from the most impeccable among us.
Thank you. Are there any other comments? Is there any public comment on this item? Seeing none. Move on to the next item, please.
So are the parties that are here aware now what's going to happen next? I just want to, they leave here knowing that it's going to be calendared by a committee in August?
So, does this get forwarded by the chair of the task force, or can a chair of a committee choose to hear any item at any time?
Well, once it's calendared, I believe the administrator would notify the parties in interest when it will, when it
No,
will.
I'm asking you a slightly different question.
Yeah.
Of our city attorney.
My sense is once it's with the full task force, as it is here, it is the chair of the task force that would decide. If there are other matters that a chair of a committee wants to calendar, that's up to the chair of the committee. But this is right now with the whole body, and I think that it's within the discretion of the chair to decide where it should go.
If I may suggest, what I think a good procedure would be is if the administrator could check in with Lieutenant Mahoney as of August 1st, or if this is posted prior to August 1st, which hopefully it will be because Lieutenant Mahoney said no later than, Lieutenant Mahoney can notify Chris of that issue. Chris can notify the chair, whoever is the chair of the task force at that time, and notify Mr. Hartz that it has been posted. And if the chair at that time believes there's further action required, in the chair's discretion, they can calendar it for a committee meeting or the full task force meeting.
Of course, we'll have a new chair of the task force then, and the makeup of the Compliance and Amendments Committee might also change by that time.
Indeed.
Nothing is firm.
I'm comfortable with that. Does anybody have any issues with that? Okay, so this was going to happen. Thank you. Should we move on to the next item?
The next item is the report from the Complaint Committee meeting of June 9, 2009.
Members, what's in your packet is an accurate reflection of our meeting. We went over the Weston B. DHS matter, Hannah Leung and Lydia Fong, Alvin X, and the mayor's office, and Mr. Hartz. That's about it. That concludes my report.
Thank you. Is there any public comment on this item? Seeing none, can we call the next item, please?
Yes. We might want to. Oh, never mind. I guess we're going to do items 1 and 2 after item 16.
Sure.
Okay.
Item 15 is a report by the Compliance and Amendments Committee on meeting of June 9, 2009.
What you see in the minutes is an accurate reflection. I did forward some minor corrections to the administrator. I guess they got there too late for the changes to appear in what you see. But by the time we vote on the minutes in compliance and amendments, the corrections will have been made. Just want to call your attention to a couple of things. The electronic guidelines still a work in progress, and the amendment annotations still a work in progress. All members of the task force should by now have received those annotations, and I would strongly urge and request that you look through them and kind of make sure that all the I's are dotted and the T's are crossed, etc. And of course, if you want to make any substantive changes to the amendments, the time's getting short. So
I have a question. Are we going to have a meeting like we did last year and go over them?
I would say it's a good idea.
Yeah, because how many pages are they? Because I printed them out, and I think they kept on duplicating, but it seemed like there were quite a few pages. Do you know offhand how many?
Through the chair, I don't, but I can just walk over across the hallway and have a look.
Were they circulated to members?
Yes.
Okay.
Because I really want to commend the CNA committee. They've done. I just looked them over, but they've done a beautiful job, and I know how hard that stuff is.
I think the commendation goes mainly to Member Craven Green.
Yeah.
And
Yes.
Frank Darby. Frank Darby had to manually change all of the suggested amendments so that we could have a document that could be reasonable file size.
Yeah,
what I would request is that if members see any substantive or non-substantive changes, if their recollection of what was done or something is, an annotation is missing or an annotation is incomplete or an annotation is wrong, to either plan to appear at the next Compliance and Amendments Committee to submit those suggestions, or if you can't attend, if you just submit your comments to Chris sufficiently in advance of the hearing, they will be included in the packet, and therefore we can discuss those suggested revisions to the annotations during the next Compliance and Amendments Committee meeting.
Any other comments? Is there public comment on this item? Can you call this 16?
16 is the report by the Education Outreach and Training Committee meeting of June 11, 2009.
Oh, sorry. We had a couple of interesting presentations last time, at least one. It was somebody, the IT director of the planning department, and he wanted to know how many pages he had to provide in a day, and he had some concerns about electronic transmission of documents, and so we decided that should come before the full task force, and I forgot to mention that to you, so made a note to call you about it so we can go on the full agenda. Okay. The other thing was the tendency of the planning department to require appointments for reviewing documents, and unfortunately the person who was supposed to be notified to come to the meeting wasn't, so I presume that we're putting it back on the agenda, and we asked, I believe, somebody named Forbes who's supposed to be notified, and that will be on the agenda of the EOT committee in July, if I'm still chair. The other thing is that we're really getting very active on presentations. We made one yesterday to the HIV Care Council. There were 40 people there, and they were very appreciative. Loads and loads of questions. I mean, we could have gone on for an hour. We passed out this brochure. We also passed out a PowerPoint presentation. So we're supposed to make a presentation to the Coalition for SF Neighborhoods. That's 40 or 50 neighborhoods citywide. We're doing that in March, and we have sort of a nibble from the Glen Park Association, and we're continuing to do outreach.
Could I request that someone forward the PowerPoint presentation to me for my review, just to make sure it's consistent with current law?
There's only one PowerPoint presentation. I think it's an email form, so maybe you could email it to Member Craven Green.
Okay. Thank you.
I'll email to you right now.
Wonderful.
Can you add the item that she mentioned to the full task force for July? Thanks.
I guess I have one more, and that's...
Also notify the Nob Hill Tenants Association. I think they were a party and interested.
Yes.
We're doing some publicity, and I'll let Mr. Johnston talk about that, because there was some question as to whether or not we should bring it up here, because there are certain issues about the production and so on that maybe the full task force might want to look at. So Doyle, do you want to take that?
I believe that was in the minutes, and I had also asked Ms. Craven to look over that. We had contacted YBR Promotions about EOT and the General Task Force and campaign strategy on how to raise more awareness and participation from the public. She had a number of strategies. Her name is Miss Tillman, and she is volunteering to come back and give a model. But the concerns with was what Mr. Lorente brought up. With, do you remember?
It's basically, we're going to have to do a contract. The question is, who can do a contract? Can this body on its own do a contract? Is it something on part of the city? Is it tied into the Board of Supervisors? What are the obligations? What are the expectations? What are the limitations? So these are things that a committee can on its own do, and actually maybe it'll even have to go beyond this body, but nevertheless it should come here to figure out what the parameters are.
I'm sorry, I read the minutes and I was confused about what was being proposed. It wasn't clear to me at all.
Basically, this organization would do some type of printing and promotion work on behalf of the EOT.
And would that be donated, or would it be for?
Well, that's what is consideration. That's the part. Yes.
Right. I mean, if someone wants to, in my view, if someone wants to donate resources to the task force, to the city, for the city's use in a campaign, there are, I believe, we'd have to ask the city attorney's office, but I believe those can be accepted. They may have to be accepted by the full body. Depends on what they are and what the materiality is and what the level is. But generally, it's to my understanding, it's not a big deal. And I may be misinterpreting. I may be like thinking of financial gifts or gifts for certain reasons. But it's kind of like the Chamber of Commerce saying, we want to send 6 supervisors to Washington, D.C., and depending on how that's done, sometimes it has to be approved by the board and sometimes it doesn't. So basically, we need to know what I couldn't get is, what is the proposal? What are they offering to do?
Print flyers, not brochures. That's very basic. And go to places where there were large bodies of people, like Pride, and just give out a simple thing that directs it to our website and create awareness. Now, the thing on this is what does both parties get out of it? She emailed me in contact with like a green printer who may be willing to do the printing for free, to have their name on something that reflects the City Hall, and then have her label on it on the flyer that reflects. So it's also, it's what's good for the goose is good for the gander in that process.
So I just wanted to comment on that too. I mean, it was always my understanding that anything was being done was pro bono.
Right. So, I mean, if something's being done pro bono, and the only thing that the person who's doing it pro bono expects is to have their name on it, or contributed by, or paid for by, or printed by, then I think we can just do a call to the city attorney's office, and if there doesn't need to be any board approval, then I think it's fine if the chair of the EOT wants to approve it and to do it. If it turns out that for that there needs to be city attorney approval, then we need to follow up and find out what it is. But if basically, I think what Mr. Lorente needs is, here's the proposal. The proposal is this person it needs to be concrete, right? Here's what they want to do for us. They want to submit a flyer, they're going to hand it out for free. In exchange, it's going to have their name on it and the printer's name on it. It won't cost the city anything, but they want to have, this recognition. Then Mr. Lorente can run that through the appropriate channels at the city attorney's office, and we'll have our answer. But it can't just be mushy. It can't be like, well, I think they're doing that, I think they're doing that. It's like, what's the proposal? Give it to Mr. Lorente, and he will tell us what to do next. I mean, it's great. I mean, I think we should follow up on it. I don't mean to sound dour.
Any other comments? I'll get back with Mrs. Tillman on that.
Yeah, why don't we just put it on the agenda for next time? Just follow up. Let us know. Let us know, Doyle, if you
If
want.
she's available.
Let us know if you
Yeah.
want it on the agenda.
I don't know if I'll be here on next month's EOT meeting. So I'm like, and I really need to check with her first.
Okay, well, just let us
Yeah.
know.
Yeah. I don't think it necessarily needs to be on an agenda. I mean, if you're communicating with this person, you find out there's a proposal, and just keep Member Cawthon in the loop, and once you have the idea, wing it into...
We'll follow up on it as
All right.
appropriate.
Any additional comments? Is there any public comment on this item?
Yes, having attended the June meeting of EOT and having presented my case earlier, I still would like to state that I find it impossible to accept the fact that the chair of that committee will handle my matters in a fair manner. Missing one notification of one meeting, that's one thing. 3 different meetings, that's something completely out of whack. Having meetings when there's not a quorum, even though your own bylaws say that you shouldn't hold a meeting if there is a quorum. Not following your own bylaws when it's assigned to this EOT rather than what your bylaws stated at the time the determination was entered. It seems like you want to do everything except talk about what a person comes before this board to talk about. What we have is little monologues going on. The complainant gets up and says, this is what I think and these are the things I'm concerned about, and then has to sit down and shut up while members of the board talk about whatever they want, whether it has anything to do at all with the complainant's complaint. I have heard people pass information. Mr. Hart said this when Mr. Hart's didn't say that. I've heard the chair of the EOT say that the police have done certain things. Go to the index of records and see if there is one single thing for the police commission or police department after 6 months. There's nothing. And passing it off as, oh, yeah, they said we're doing this. What have you seen that shows they're doing it? Has any one of you gone to the index of records, compared the index of records with what it actually says under the Sunshine Ordinance to determine whether or not any action has been taken, or are you simply in here repeating words you cannot, and for some strange reason, refuse to make any attempt to verify? I do not feel that going before EOT with the chair operating under the way she does can give me any chance of a fair hearing before that committee. That's one of the reasons I asked it to be changed. And I think, very honestly, my next step, since I haven't had any action because I wanted to see what you do, is I am going to file an ethical complaint against Ms. Cawthon as chair of that board, using the same information that I did today to see if we can't get someone to make an attempt to give an appearance of being fair.
Thank you. Is there any additional public comment? Seeing none, let's move on to item number 1, election of officers. Ernie, can you explain the process for this?
Item number
Well, why don't you read it first?
Item number 1 is the election of officers, chair and vice chair of the Sunshine Ordinance Task Force.
Normally, you would have you would invite nominations from the body to positions, and then take a vote on those who have been nominated. First, of course, the nominee would have to agree. So usually we would have 1 or 2, but if you have a really tight race, you may have 3, and then you could spend the time lobbying, and then. But if that doesn't happen, basically you get nominations, and then you'll call. Okay, we nominate 1, nominate 2. Okay, then you'll call for the vote and see.
You call for the vote on each individual first, the first nomination, or how do you do that?
Yeah, the first nomination.
Or is it that people voice vote for their choice? Do you see what I'm saying?
I don't think we've done voice votes in the past. I mean, I'm just going back and what we've done.
So, nomination 1 for Member Smith.
Right.
We call that's the first nomination, then we vote on the first nomination.
If that one,
yay or nay. And then number 2, Mrs. Smith. Yay or nay? Do you see what I'm saying? Is that how it works? Because I honestly don't recall.
Yay or nay? I don't.
I believe nominations come first. Mr. Smith is nominated, and if somebody wants to make a nomination for Mr. Jones
Mrs. Jones.
or Ms. Jones, whatever,
John Doe.
and then, well, John Doe, no, that I won't comment on.
Yeah, too
I'm not
slippery.
qualified. But I think after all the nominations come, then somebody moves to close the nominations, and then the vote is taken.
But how is the vote taken, Member Nay?
Then they vote, Member Neber will vote for Smith, Jones, or John
Okay,
Doe.
all right.
Right.
So it's
and, I mean, and you don't get to vote more than once.
right, that's, yeah.
No.
I understand.
You can vote early, but not often.
But I thought in the past had we ever done nominations at one meeting and the vote and the election at the next meeting?
No.
No, it was always
Maybe
at
that
the
was a
same.
long time ago.
Maybe
We did.
in the beginning, but no, in the recent history.
Yeah,
Not on the
we,
seventh
that's the way
day.
we used to do it, but I guess we don't do it that way anymore.
So we'll do nominations and then voting on chair, and then we'll do nominations and voting on vice chair.
Yes.
Okay. Is there nominations for chair?
I nominate Erica Craven Green.
Okay.
I would like to nominate Chair Chu.
You don't second nominations, right?
I don't think we
Oh.
need to.
It doesn't require a second.
Doesn't require a second, but the candidate can accept or decline if.
So let's get all the nominations first.
I want to nominate Richard Nee.
I move that we close nominations.
I would respectfully, with all due respect, decline the nomination for chair. I feel I have enough work on the Compliance Amendments Committee, and potentially, if renominated as vice chair, so that's where I'll throw my hat. But I
Okay.
appreciate the nomination deeply.
Okay, so there's an opening. Does anyone want to fill it? There's 3 candidates, only 2 now.
I would prefer not to do it. It's a hard job. It's a hard job. It's a lot of work, even though Erica does most of it.
So you're declining the nomination?
If you will accept, then I will decline, yeah.
Well, I will accept.
I move that we vote on the nomination.
Rick Ney? Okay.
On the nominations, Member Craven Green.
I need.
There's only one nomination.
Right.
Okay. Member Nee.
Aye.
Member Cawthon?
Aye.
Member Cawthon, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Caneva?
Aye.
Member Caneva, aye. Member Johnson?
Aye.
Member Johnson, aye. Member Chan?
Aye.
Member Chan, aye. Member Goldman?
Emphatically, aye.
Ooh.
Member Williams excused. Member Chu?
Aye.
Member Chu, aye. Wait, which nomination is this for?
This
That
is
was for
for
chair.
president.
Oh, chair.
Chair.
This
Yeah.
is chair.
Woohoo, it's president now.
President.
Yay.
Yeah, president. So that must mean that he's not chair of the CAC.
So now we'll take nominations for vice chair.
I nominate Erica Craven Green for vice chair.
Are there any additional
I move
nominations for
that we
vice chair?
close.
Open,
Are
close.
there any additional?
So
I
moved.
nominate Member Chu for vice chair.
I'm thrilled with the nomination, but having done this job, having done chair, I'm not sure if it could all be done without Erica.
I
So I would decline, actually, for the sake of the organization. I would actually decline.
Well, I respectfully disagree. I think former Chair Chu would do a fine job.
I have declined. Back off. Any other nominations? Nominations are closed. We vote on
Vice Chair.
the vice chair, yes.
On the Vice Chair, Member Craven Green.
I guess I.
Member Nee.
Aye.
Member Nee, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Enthusiastically, aye.
Member Williams. Member Williams excused. Member Chu.
Aye.
Member Chu, aye. Madam Chair, we have 9 ayes.
Thank you.
Okay, congratulations to our new administration.
Thank you.
Madam Chair, as incoming chair, I would request that people think about the committee assignments they would like and forward them to me at your earliest convenience.
Thank you. I think we just have number 2.
Item number 2 is the approval of minutes for May 26, 2009.
I have a change, if I may, a substantive change. I just want to make this clear for the record. Perhaps I wasn't clear during comment, but this is on page 11 of the packet, page 3, under Member Craven asked Dr. Brown. The second long sentence that I tend to use, because it seemed like Dr. Brown relied on the request for follow-up, she said she wanted a statement from Dr. Brown that when a public records request is received, the doctor will, as part of his burden of responding. There's an extra will there. We don't need that. Search the emails and other repositories of information for all employees who are likely to have responsive information. So for all employees who are likely to have responsive information. That's the legal standard, and that's what he didn't do in that situation. So I intended to make that clear in the comments. I think it was, but perhaps I wasn't as clear, but that was the intent of my comment. Any other comments, please?
Yeah, I just have something small. It's on page 4 of those minutes, under item 509020. In that second paragraph, 4th line, it says, placing document in a draw. I think it should be drawer with an ER. And then I think the next 2 sentences.
Depends if you're from the South.
Yeah, unless you're from Alabama. And then I think the next 2 sentences can be one sentence. He also said the MTA website is not user-friendly, period. Yeah, I think that should just be one sentence. It's minor, but that's the kind of mood I was in today.
Any other comments? Yes, please.
On page 5 of the minutes, 13 of the packet, near the top, public comment should be clear with said or stated or something. Verb missing. Also, Member Williams' comment, those of us who know her knows that she meant this in all, good faith, but if anybody reading it might wonder. She says, Member Williams said that departments need to keep in mind the class of residents who are not computer literate, and I think that should be, there needs to keep in mind members of the public who do not have access to computers.
A little softer.
Yeah. Anything else? Let's take public comment. On the election and this at this time. Is there any public comment on either of those items? Seeing none. Administrator's report.
To date, we have 3 more complaints, but only 1 scheduled for the July meeting.
Anything else?
Concludes my announcement.
Is there any public comment on the administrator's report?
Yes, I would like to have the administrator look into the fact that the letter of determination 08056 is not listed as a determination on your own website.
Can you do that, Chris? Thank
Yes, ma'am. Sure.
Any other announcements? Questions? Discussion items, please.
Since we're on announcements, some of you probably know Joe Lynn, former Ethics Commission staffer and member. Mr. Lynn has for several weeks now been hospitalized with a serious illness. I talked with him briefly today, and I am pleased to report that he seems to be well on the mend. Things are looking up, and anybody who would like to communicate with Mr. Lynn, he is at the California Pacific Medical Center on Buchanan at Clay, and the phone number there is 600-6000.
I'll just say something about that, too. At the HIV Care Council yesterday, it was also announced that Joe is at CPMC, so and everybody seemed to be quite interested. I'm glad he's doing better.
Any other announcements? We are adjourned.